my name is Song Chen Yu, and my student ID is 0375142. Welcome to my presentation on the contemporary relevance of the ancient land law maxim, quis est solum, quis est usque, et colum, et inferos. So today, I'm going to examine how accurate this maxim is in defining the extent of a landowner proprietary rights in airspace above their land, in the subterranean space beneath it, and also the surface of the land. To begin, we need to understand what this maxim actually means and where does it come from. The phrase essentially states that whoever owns the soil owns everything up to the heaven and down to the depth of the earth. For centuries, this has been used as a simple way to explain the three-dimensional nature of land in the English land law. But this immediately raised the question, what does three-dimensional land really means in a legal context? We all know, in mathematics, three-dimensional space refers to the length, width, and the height, basically a cube, like the one we always draw in the secondary school. But applying that mathematical idea directly to land law today doesn't make much sense. So for me, a more reasonable interpretation of this maxim is this maxim attempts to explain the extension of a landowner's rights across three layers: the sky above, the surface itself, and the ground beneath it. However, if you interpret the maxim literally, it becomes absurd. We cannot scientifically locate the heavens, and we definitely couldn't find hell. So claiming ownership up to the sky and down to the hell would give us an impossible amount of territory. So for example, imagine, I'm just standing in England right now, and I say I own my land all the way down to the antipodes, which would place my ownership somewhere in New Zealand. Obviously, this is impossible. Or if I'm from Penang, and I claim my land rights extend through the earth until it reaches the Amazon rainforest, just simply doesn't make any sense. So it's very important to understand this maxim is not interpreted by literally, but mere historically. Most modern scholars trace its intellectual origin to the Roman law, particularly through the occurrence of Bologna in the Glossa Ordinaria in the 13th centuries. Roman jurists already understood that the land could not be viewed as just a flat surface. It was inherently connected to the space above it. However, there is no definitive proof that the legal maxim originated directly from the Roman law. Some minor authorities even point to Jewish law. For example, in the Talmudic text Baba Batra, the Mishnah discussed property sales and explained that a seller does not automatically transfer a well or a cistern unless the deed explicitly states from the depth of the earth to the height of the sky. But regardless of its ancient root, we do have a clear evidence of how the legal maxim extended or entered into the English law. In Bury and Polk, both Lord Coke and later Lord Blackstone has referenced it, making it a formal entry into the English common law. At that stage, it functionally mainly as a supporting principle, a way to justify the landowner's rights to control activities above and below their land. So, the question for us today is, in an age of skyscrapers, drones, commercial aviations, pipelines, and deep-level resources extractions, does this maxim still accurately define a landowner's rights? My position is, while the maxim remains a useful conceptual starting point as a flagpole, its absolute nature has been heavily limited by case law and statutory reforms. So, in today, its value lies more in symbolism, reminding us that the land is a three-dimensional thing rather than just providing a literal rule. So, the legal maxim now has been rephrased to fit the realities of modern technology and public interest. So, before I dive into the three-dimensional of the surface, I'd like to raise the questions for everyone. Whether the ownership of land is extended to the enjoyment of land itself, or the extension of ownership is extended to the absolute ownership for the whole land. So this is a very important question, and we will explain it at the end. So when we move upward, the law adopts a far more restrictive approach. This is for airspace law, airspace enjoyment in land law. So the key modern authority is Bernstein of Lake and Sky Views in general. In this case, an aerial photography company flew a plane over the claimant's land to take photos. The court had held that the landowners does not own all the airspace above their property. Instead, ownership is limited to the height necessary for the ordinary use and enjoyment of the land and buildings. So this principle creates what we now call the upper stratum and the lower stratum. The upper stratum means airspace beyond a certain reasonable height, which is treated as public navigable space, and aviation legislation has also reinforced this. Under the Civil Aviation Act 1982 and later the Air Navigation Order, flights at a reasonable height cannot amount to a trespass. Cases like Hatton and United Kingdom has shown how courts balance private rights with public interest in air traffic. And also, the rules of the Air Regulations 2006 have follows the same approach in balancing the rights of humans and the rights of the government. So, however, the lower airspace is still protected in this case. In the earlier position, in the case of Pickering and Rudd, it shows that balloon does not amount to trespass, but cases such as Kelson and Imperial Tobacco, Griffith and Dent, and Leichhardt and Majid has shown that even minor intrusions such like a signboard, an extractor fan, or even an advertising structure can also amount to trespass. So the modern interpretation has gone against the ancient interpretation that a balloon does not amount to trespass. In now, lower stratum is protected. And while in the upper stratum, it is not protected because it is counted as a public place. So this demonstrates the clear judicial rejection of the old maxim in the context of airspace, and courts now has more clear rule about the law in airspace in land law. So next, I'll dive into the surface level. This is where the maxim retains its strongest influence, I would say. So the basic rule or the basic maxim in land law, or I mean in the surface of the land, is quid plantator sulo sedit. Means wherever is attached to the land becomes the part of the lands. This includes building, fixtures, trees, and permanent structures. The classifications between fixtures and chattels relies on the 2-degree test from the case like Holland and Hodgson, Elitstone and Morris, and more recent case, Caddick and Whitstand Bay Holiday Park. The surface dimension is also where the owner's proprietary rights are clearest. For instance, in Wandsworth District Board of Works and United Telephone Company, telephone wires strung across the private land were held to be a trespass. Similarly, in Griffith and Dent, even minor encroachments into airspace like such a higher airspace above the surface land were actionable. So at the surface level, the maxim still functions effectively because physical control and possession align closely with ownership. But the biggest challenge arises below the surface, which I will now turn on the core of our discussions, the Supreme Court's case in the Bocado case. Next. So in the underground dimension, it's where the maxim's relevance become more contested. Traditionally, based on the older authorities like the case of Mines and Risby and Melville, ownership did extend downward indefinitely, even to the depth of the earth. This was easy to maintain when only basement or shallow excavations were involved. But since the world has developed the modern infrastructures, cable tunnels, rail lines, and especially oil, gas, and petroleum pipelines make such an absolute rule impractical in this case. So this brings us to the Bocado and Star Energy UK onshore, the case, the leading authority now in the beneath of the land. So in this case, in the Bocado case, Star Energy drilled pipelines diagonally beneath the claimant's land at depth between 800 to 2,900 feet to extract petroleum from licensed wells. The Supreme Court held that even at such extreme depth, the drilling constituted trespass because the company failed to secure permission from the landowner. So the question is, do the owner own such extension of rights to the depth of the earth, and how much rights does he have? So as the court stated just now, it has affirmed that the court have the right, but the decision has, so technically the decision of the Supreme Court has affirmed the maxim in relation to the lower stratum. So, but however, the interesting part is that the court held that the compensation was awarded only by minimal amount, only £1,000. Despite the company earning millions of pounds, the companies were supposed to give 9% of the profit, but in this case, the court just award £1,000. So this case states that even though trespass really exists, the effect of the trespass is heavily moderated. The judgments also highlighted the role of statutory frameworks because oil and gas are governed by the Petroleum Act 1998 and coal is governed by the Coal Industry Act 1994. Private land ownership is already limited by public regulatory interests. So what does this mean? It means that although the landowner rights are protected in this case, did the Star Energy amount to a trespass? However, the act itself, the landowner did not suffer much damage, so the compensation would be limited. Furthermore, later commentators and courts note that if the maxim were applied literally, it would obstruct all modern subterranean infrastructure. Following the reasoning of Kevin Gray and other scholars, subterranean ownership must now operate with functional limits rather than absolute vertical control. So the courts come up with a twofold test that whether the extension of rights of land should be extended to the extreme limit of the earth or just stay at a reasonable limit of a person that could reach. So the outcome in this case is that the outcome in this Bocado case is that it confirms that landowners do own deep subterranean space, but it also shows that remedies for interference are limited and public interest statutes significantly restrict private rights. So, having analyzed of all three dimensions, above, at the surface, and below it, I now evaluate the contemporary accuracy of this legal maxim. Overall, this legal maxim still remains important symbolically because it provides a conceptual reminder that land is three-dimensional and we have the rights extended to where. But the courts, or maybe the scholars, still cite it when explaining the structure of land ownership, but it just does not longer, it just did not accurately explain the law now. So we can see in the three clear trends. In airspace, the maxim is mostly rejected in the higher stratum, but the lower stratum, the rights are still preserved. Courts prioritize the reasonable use and public navigations. New technologies like drones, satellite imaging, telecommunications towers, and aviation make absolute ownership impossible. Scholars such as Gray describe upper airspace as thin air where property rights should not be extended to. At the surface, next is at the surface. So the maxim remains mostly accurate. Ownership is clear, control is direct, and trespass rules apply strictly. Fixtures case shows continuity with traditional principles. So not much things to extend. Lastly is the subterranean space. Bocado case has reaffirmed ownership but revealed its limits. Statutes like Petroleum Act and Coal Act remove state-controlled minerals from private ownership. Pipelines, tunnels, sewers, and energy infrastructures require flexible rules but not an absolute death-based ownership. So academic commentators like Sarah Neal and Martin Dixon argue that subterranean space must reflect practical public needs but not pure unlimited private control. So, as a conclusion, the maxim is no longer an accurate legal rule. Instead, it survives as a conceptual shorthand for the layered three-dimensional nature of land, but the actual law now depends on statutory interventions, technological developments, and judicial balancing of public and private interests. The modern position is therefore a compromise. Ownership is strongest at the surface, weaker below ground, and weakest above the air. This reflects a shift away from strict vertical ownership towards a functional, policy-driven approach. To answer my first questions in the start of this presentation, I would say now the maxim has been evolved. Now the court, I would say it more focused on the rights that the ownership, the extension of right of the enjoyment of land rather than the absolute ownership of the land. Because in ancient times, the absolute ownership of land is very important, but now as the laws have evolved, it's just not the case right now. So thank you for listening. This concludes my presentations.